Hello friends, welcome to Insights Again Initiative. In today's video, we are going to discuss about weekly current issues, and this is the week number 38. In case if you did not follow the previous weeks, please feel free to find in the weekly issues playlist. There you will find the previous 37 weekly current issues. So in today's video, we are going to discuss about following 6 topics. First, I will give you the subject name related to the topic, then we will discuss in detail. First, candidate right to privacy from voters. It is the candidate's right to privacy from voters, polity related one. Curative petition, polity. International Narcotic Control Board, IR. Doctrine of Harmonious Construction, polity. Peace clause in WTO, economy. Misleading advertisement, this is related to economy. So these are the 6 topics we are going to discuss in this particular video. First, let's see Supreme Court's judgment regarding the voters' right to know versus candidate right to privacy. There are 2 rights. So first we'll try to understand the context, then I will explain. The context is Supreme Court ruled that candidates have right to privacy from voters. They are not required to disclose every aspect of their personal life as well as the position. So this is about Supreme Court saying that, this is the topic number 1. Supreme Court saying that candidates, whoever contesting in elections, okay, their information related to them, okay, information related to elections, okay, related to election that can be revealed, and voter has the right to know that information, but other personal information voter do not have the right to know, because candidates also they have the right to privacy. This is the first topic. Okay, now let's see. Supreme Court is saying that in the MLA election where there particular MLA election challenged that MLA did not declare vehicles as an asset. In this case, Supreme Court mentioned that, and it given judgment in favor of that MLA, because in this particular case that MLA he sold already that particular asset. Once you sold a particular vehicle, it cannot be considered as an asset to you because it is not with you. Okay, in this context, Supreme Court saying that the statutory provisions in the Representation of People Act 1951, what the sections are saying, section 33 of the RPA Act 1951, it is saying that nomination for election candidate, they require certain valid information they have to provide, and they provide such information in the form of nomination paper. And section 36, it says that nomination papers will be scrutinized by returning officer and they can reject the nomination if there is a defected information provided. These are the 2 sections related to nominations. Supreme Court mentioned that yes, voters has right to vote or right to know about the candidate information, but that information must be relatable only to the election, not related to every information. And non-disclosure of certain personal items, it is not required according to section 36 of the RPA. And candidate privacy on matters irrelevant to their candidature is not a corrupt practice, because they are not going to influence the election process anyhow. They don't need to disclose all the information. In India, voters are having certain rights regarding the elections. Those rights are right to know. Okay, that is the reason Supreme Court directed all the candidates to declare whatever the criminal charges they are facing. And voting rights of NRIs. NRIs can have the right to vote by coming to India. And voting rights of prisoners. Prisoners do not have the voting rights. Right to vote, that is a right not to vote, nota. And tendered voting right. In case if someone vote is being casted by another person, then they can cast the tendered vote. And voting rights of the disabled citizens. Regarding this, recent Election Commission of India, it is providing voting from home. So these are some of the rights to voters in India. Next, curative petition. First, let's see the context. Recently, Supreme Court decision to allow curative petition in the DMRC case signifies the expansion of its powers beyond constitutionally prescribed processes. Here you have to know what is a curative petition. Curative petition. Okay. So curative petition is all about review by the court judgment. Okay. Initially, when Supreme Court given judgment on a particular case, reviewing the judgment is known as review petition, and Again, in exceptional cases, Supreme Court will review that again, that is known as curative petition. Generally, curative petition will be allowed in where if a party feels that if they got any gross miscarriage of justice, or if the principles of natural justice is violated, then Supreme Court entertain this kind of curative petition. Actually, this review petition and curative petition, they are enhancing the jurisdiction of the Supreme Court. Now, the first time generally this curative petition will be allowed only in cases where principles of natural justice is violated. For the first time, the curative petition is entertained even in the commercial case also. In the commercial case also. Of course, this is having some negative impact also. It is indicating that Supreme Court is intervening beyond its limits, and when in the commercial cases also, if curative petitions are entertained, means that will dilute the original decision given by the court. So these are the aspects. Now let's see. Curative petition. Generally, it is a very rarely used judicial one. It aims to correct any miscarriages, and that means in any previous wrong things while delivering the judges. To correct that, curative petition was introduced in 2002 in the judgment of Rupa Hura versus Ashok Hura case. However, exercising the curative petition, curative thing in commercial case is very raised. It raising serious questions, and it is raising questions regarding the finality of the Supreme Court ruling and the principles of minimum judicial interference. But these principles are getting violated. Curative petition is entitled if petition establishes, if they are able to establish violation of principles of natural justice, if they are able to establish that principles of natural justice is violated, and if the judge failed to disclose his association with the subject matter. That means previously the judge is related to one of the petitioner. In that kind of conditions only curative petition will be entertained. Next, third one. This is regarding the International Narcotics Control Board. Recently, few bodies in the UNO, they've been re-elected, and in some of those bodies, India got re-elected again. In such body, one of such body is International Narcotic Control Board. Actually, the main purpose of the International Narcotic Control Board is it regulates the drug supply across the world, and it also ensures that drugs should not be used in a wrong way, and it also controls the illegal trade in the drugs. India's nominee Jagjit Pavadia, she was re-elected for a third term to the International Narcotic Control Board. Apart from that, India re-elected to certain international bodies such as Commission on the Status of Women, the Executive Board of the United Nations Children Fund, and the Executive Board of the United Nations Development Program UNDP. And this INCB, it was established in 1968, and it monitors the implementation of the International Drug Control Conventions, and it ensures the adequate drug supplies for the medical and scientific uses, and it also prevents the diversion of the drugs to the illicit things. So this is regarding the International Narcotic Control Board. Next, harmonious construction. This is the fourth one. The Supreme Court, while refusing to condone, criticize the delay. How much delay was happened? Around almost 5,659 days delay in an appeal. Normally, if you think that you did not get a fair justice in the lower court, you will appeal immediately or within certain time limit. So this delay was happened in 5,659 days of delay happened. So while giving the judgment in this case, Supreme Court used the principle of harmonious construction. What is the principle of harmonious construction? Okay, principle of harmonious construction. Okay, so principle of harmonious construction is, if there is particular law, and in this law, if one of the clause is contradiction to the law, then we will consider the broad objectives of the law rather than one contradicting statement. So that is known as principle of harmonious construction. And for example, one more example, if two clauses are contradicting to each other, but they are trying to achieve the overall objectives of the law, then we will apply the principle of harmonious construction, because these two, even though they are contradicting to each other, they try to achieve the objective of the overall objective of the law. So this is how, this is an assumption that all the clauses in a particular law, they will be in harmonious with the overall objective of the law. That is the principle of harmonious construction. Now, Supreme Court, say generally there is certain time limit. Okay, when you get a judgment, to appeal on the judgment, you will have certain time limit, that is known as a limitation period. Now, Supreme Court did not criticize that the delay, but while giving the judgment, Supreme Court outlined that certain principles regarding the principle of harmonious construction, that is public policy basis of limitation laws. Limitation law means, for example, limitation law means if you commit any promissory note to anyone else, the promissory note limitation period is 3 years. That means if someone, if someone say that they will give money to you, whatever the money they owe to you, they will give you within this much date, and they wrote a promissory note to you, and if they did not give you, you have to file a case within the 3 years of the promissory note only. Okay, that means after the 3 years, the promissory note is invalid. That is known as limitation period. The public policy basis of limitation law, that means, so whatever the laws made by the government regarding this kind of limitations, so whether they are the right or wrong, court will examine. The strict interpretation of section 3 and the liberal interpretation of the section 5 of the Limitation Act. So these are, you don't need to go into these details, but limitation means, I hope you understood what is a limitation. Further information, if you like, you can read the next principles also. Doctrine of harmonious construction, it is a legal principle used to interpret statutes which are conflicting with each other. When there is an inconsistency between the statutes or provision, then the doctrine, this doctrine will be used, and by using this doctrine, courts will interpret why those two certain provisions are contradicting to each other, and this doctrine believe that even though provisions are contradicting to each other, they will try to achieve the overall objective of the law. All provisions work together. This is the assumption. Next, WTO, peace clause. India invoked peace clause in WTO. What is this peace clause? Peace clause prevent the legal action on the developing countries. That is the peace clause. Okay. So India invoked peace clause. Why some countries, while alleging that India violated certain WTO norms. What are that? We'll see. India invoked peace clause at WTO for the 5th time for the marketing year 2022-2023 as it breached the prescribed subsidy limit for rice. What is that? Let's see. Despite breaching the 10% domestic support ceiling, that means according to WTO rules, the subsidy should not be more than 10%. Tell me students, so in WTO, before WTO, which international agreement used to govern this, international trade laws, which international agreement used to govern? And there are no immediate repercussion due to the peace clause. This peace clause provides a temporary protection to the developing countries until a permanent solution is arrived. The peace clause in WTO, it refers to an agreement that temporarily prevent the developing countries from legal challenges. It was established during the WTO's Bali Ministerial Conference in 2013. This clause allows developing countries to provide subsidies even beyond the prescribed limits for certain agriculture products such as rice, wheat, without facing any immediate penalties. This peace clause provides immunity until permanent solution is found. That is what we discussed. Next, this is regarding the Patanjali products, and this topic is about the misleading advertisements. So Supreme Court given a certain directions that this Patanjali products, they have to face the contempt of court, and despite the second time apology also Supreme Court not yielded. So what is this contempt of court? Tell me guys, under which article Supreme Court will issue the contempt of court? By using which article Supreme Court will issue the contempt of court? The Supreme Court declined a second apology from Baba Ramdev and Patanjali in a contempt case over the misleading advertisement. Misleading advertisement is about promoting through promotional message or claims that deceives the characteristics of the benefit. That means even though a particular product is not having that quality, you are claiming that product is having that quality. That is about the misleading advertisement. Okay. Supreme Court criticized that deliberate violation of the Drugs and Magic Remedies Act. So this Drugs and Magic Remedies Act is all about when a particular product is not having the medical quality or medical benefits, even though it is not having, if you are claiming that it is having, then that attracts the punishment under Drugs and Magical Remedies Act. The drugs and magic remedies objectionable Advertisement Act 1954, it prohibits the misleading claims about the drugs and magic remedies. Section 4, it prohibits the false impression about the drugs true character, and well, section 5, it bans the advertisement of magic remedies. Okay, so these are the two sections which allowed the courts to punish anyone who is claiming a particular substance as a magic remedy. Now, yesterday's video question. Consider the following statement. Akira, a type of ransomware, is found targeted both Windows and Linux devices. Ransomware is a type of software designed to protect. No, only first statement is right. Now let's see. Consider the following statement about the Botswana. Read the three statements and pick the right one regarding the Botswana. Next, question number 2 is about Global Unicorn Index is released by which of the following? Who is releasing the Global Unicorn Index? Next, question number 3. What is the role of dark energy in the expansion of the universe? Dark energy role. So this is about the today's MCQ question. As we reach to the end of this video, we will do some quick revision. In this video, we mainly discussed about certain issues related to weekly current affairs. And here we discussed about the detailed analysis of the weekly current affairs week number 38. I hope this video is useful to you. Thanks for watching this video. Have a great day. Jai Hind.